What started as a normal courtroom hearing quickly turned into complete chaos. A man walked into court claiming he was not a citizen, not a defendant, but a living man beyond the court's authority. He rejected lawyers, denied the judge's jurisdiction, and argued that the government had no power over him without his consent. But as the hearing continued, the tension inside the courtroom only grew more intense. This is the unbelievable real courtroom moment, where one man tried to challenge the entire legal system.
Thank you, Your Honor. So I am aware of 5 items that have been filed by Mr. Martin, I think after this case began to be pending in this court. And I'll just briefly address as to the formatting of those. I did notice all of them are handwritten. He does write a date on the top of each document, but then he usually signs off with a different date on the bottom of the document. So if it ever comes into play that there's an issue with the timing with respect to deadlines or anything like that, for my purposes, I'm just going by the date that it was received by the court, which is usually a third date that is different from the other two. So the first document I'm aware of is titled Demand for the Return of My Motorcycle. That one was received by the court July 27th, or yes, I believe somewhere around there. I'm sorry, I'm not going to the dates aren't really important, so I'm not going to dwell on those. I'm just addressing these versus actually, I think, responding to them in detail. Defendants specifically ordered and demanded that the troopers from Michigan State Police return his motorcycle in this case. That is a request of police that was filed with the court. No response appears to be required or called for from the people, so I don't have anything to say about that. Next is the motion that was filed for the disqualification of the judge in this case. And I just wanted to point out a couple things. First and foremost, as Mr. Martin pointed out, the court rule that relates to disqualification of judges, MCR 2.003, speaks to the exact procedure for that. In a single judge court, and actually the challenge judge here is the chief judge, the challenge judge is the person who decides this motion. So I don't have any argument to make as far as that, but I would point out there is a quote included in that particular motion that challenges this court's jurisdiction. And it cites a case from, what's that? Oh, yes, Penhallow versus Doan's Administrators. That's a case from 1795. And the specific quote that was cited in that case to challenge this court's jurisdiction, it's a paragraph or so. It begins with something about, heavens, let me see. I want to make sure I have it correctly. It's not really important. In as much as every government is an artificial person, a creature of the mind only, all that stuff about artificial persons. I think Mr. Martin already made some references to that. I just want to make sure that Mr. Martin is aware that specific quote does not exist in that case whatsoever. That quote that he used to challenge this court's jurisdiction doesn't exist anywhere at all, except for other cases where sovereign citizens have copied and pasted that non-existent case law, and they've been told the same by other courts. So apparently there's like a bank of things to be shared amongst people making this argument, just so he knows and everybody else out there knows that does not exist. It's not a thing. It's nowhere in that case. That full text of that case can be Googled for free. You will not find that quote. The same is true of another case he cited, Keller versus Potomac Electric Power. That's from 1923. That case also does not include that quote, those words, or anything even slightly resembling that argument regarding the power he believes is lacking here due to municipal court status. But FYI, the Michigan District Court Act of 1968 did abolish most of the municipal courts. 4 of them are left that they did allow to remain: Grosse Pointe Farms, Grosse Pointe Park, and Grosse Pointe Woods. All of those are in Wayne County. We're in Washington. So just so that Mr. Martin is aware, this is not a municipal court. It's a district court. Finally, as to the motion to disqualify, as I mentioned, that is for the judge to decide. But I might want to point out the manner in which he chooses to pursue that disqualification, including any comments or insults. For example, on page 9 of his motion, when he says that also Washington is not a real judge, but a clerk masquerading as a judge. Pursuing disqualification or recusal, or even a federal lawsuit, does not insulate you from the contempt powers of that very same court, should you choose to continue escalating that type of behavior. That's just the more you know from me. Third, next document that was filed from this court, it's titled Martin versus Mike. Plaintiff's response and response and objections to my return criminal complaint on Mike and the attached court letter that vaguely, unfairly stated filings does not comply with MCR 6.101 and 6.102. I didn't have a letter attached to that to refer to, but it looks like that is the court's rejection of an improper filing or format. I honestly have no idea who Mike is, but the people of the state of Michigan are not listed as a party in that filing, so I don't really have any response to that either. I can advise, though, that Mr. Martin mentioned earlier, and it's stated here, that the reference to this criminal complaint, because a defendant refers to himself as a plaintiff and titles something as a criminal complaint, it doesn't make either of those things true. So I'll direct Mr. Martin to the same court rule he actually cited in that filing, which is MCR 6.101. The prosecutor's approval or posting of security. A complaint may not be filed without a prosecutor's written approval endorsed on the complaint or attached to it, or unless security for cost is filed with the court. I just wanted to disabuse him of that notion that because he creates a criminal case, I guess in his mind and on paper, it doesn't mean that that exists in reality. So nothing more from that. The court's rejection of an improper filing really isn't my business. So no response from opposing counsel would apply to that. The last two things that were filed before the court are two demands. The court has already mentioned demands. I'm so sorry. It's a lot of talking happening here. I gotta refresh. Two demands. One demand for default judgment and another demand for summary judgment. Both of these I would have the same reaction to. The demand for summary judgment, summary disposition concerns parties to a civil action, and defendant is referring to civil procedure, not criminal procedure. There is no summary anything of that notion in criminal matters. Now, he made some references to Article 3 of the U.S. Constitution. That pertains to federal courts, appointment, tenure, Supreme Court justices, federal circuit and district judges. Those are Article 3 judges. Those are the ones nominated by the president, confirmed by the U.S. Senate. So this court is not controlled by Article 3 of the U.S. Constitution. But I think he knows that because he's citing Michigan court rules to sustain his argument for pretty much everything else. So that doesn't change here. Summary judgment is not a thing here. Default judgment. Now, that's not quite the way it works. I think he argued that because the prosecutor in court did not respond to the request to return his motorcycle for that first filing that I mentioned, that he should have a default judgment and he should automatically get what he's demanding because he didn't respond to it. Well, I'm responding right now, but that's not how it works either. Again, this is kind of a civil issue. There are cases where there are default judgments filed, but those are civil actions. We have traffic tickets that defendants fail to appear and get a default judgment. But if that were the case, I would have a default judgment of conviction for every criminal case where defendants fail to appear. People are on bench warrant status for 6 to 20 years at a time. I don't get automatic default convictions. So again, that's really not what's happening here. So those are the 5 things that I'm aware of. Now, finally, if it were true that, as Mr. Martin stated, that federal law trumps all state law and that all state law and state courts are unconstitutional, the state court system would not exist. And the U.S. Supreme Court would not hear cases resulting from the need to interpret state law. Mr. Martin has yet to hear, as all of us do, of state constitutions and the power of the state courts that come from those being abolished. So his reference was correct that there are people in this system who don't know any better and don't know what they're doing. I don't think present company is excluded from that. So on that note, Mr. Martin, if you want to continue without an attorney, you can, but I wouldn't recommend it. That's all from the people.
Cases like this spread fast across the internet, but inside a real courtroom, every word has consequences. What you witnessed wasn't just a legal argument. It was a collision between belief, confusion, and the reality of the law. Some people see this man as someone fighting for freedom, while others see pure courtroom chaos. But one thing is certain, this hearing is impossible to forget. What do you think? Was he defending his rights or completely destroying his own case? Let me know in the comments and subscribe for more unbelievable courtroom stories.